Welcome to IDR Intel with me, Stephen Lawson.
Me, Ian Bond.
So, you can see that there's a different format today. We've called this Two Talking Chairs because I'm the chair of the Law Society Wills and Equity Committee and Ian is the former chair of the Law Society Wills and Equity Committee. But there's a massive difference between us. As you probably know, I'm a pure contentious probate lawyer and Ian is a pure private client lawyer. But what I find absolutely fascinating is that we deal with the same problems and we come up with the same solutions, but from different ends of the spectrum. And this is what we wanted to talk about today, isn't it, Ian?
It is, and yeah, absolutely. I come from the spectrum being a lover, not a fighter, so completely the opposite end.
Can you say that, Ian?
It's been said now.
So, what's the issue that's facing us at the moment?
Well, I think we can all relate to an example of a file that we have in our firms or that we've seen throughout our career where we have had a situation where there has been a will or a lack of a will and the family aren't happy with the circumstances. And what seems to happen is they get into a bit of argy-bargy, which is where the contentious lawyers come in. But from a non-contentious side, we are unable to administer the estate. So we see things like houses going to rack and ruin because they've just been left. The deceased has died. The house has an overgrown garden. It gets dilapidated. And everyone in the town, the village knows that this is the sort of bogey house, as it were, and the kids start hanging out there and sort of graffitiing it and wrecking the place, as it were. And it doesn't go on the market because the house is in probate and the probate is not progressing because there is contention between the various different parts of the family or the people who are entitled. And a classic inheritance dispute, and we've all seen them. We can't get on with dealing with the estate, and the purpose of today is just to talk through what are the options. So when this happens, what do we do?
I think that's absolutely right. I mean, one of the phrases that we both adhere to is that estates are to be administered. And if people don't administer an estate, whether they be professional executors or lay executors, then things can and do go wrong. I mean, I've been involved in quite a few cases where people leave a house empty, they think they've got it insured, but then they haven't complied with the inspection requirements imposed by the insurance company, and then damage happens, vandalism happens, squatters come, flooding from the central heating or whatever. And insurers just don't pay out these days. And this is a common problem because they know that when properties are empty, there's an increased risk. So it's a common problem. And one of the cases that we dealt with, there was a house that got completely covered in ivy. And I mean completely covered. It went all over the roof and everything. You just couldn't see the house from the road at all. And there was damage being done. And the local kids start saying it's the witch's house and things like that. And then at another level, if you've got shares in an estate, then they can go up and down as well as up. If you've got premium bonds, you can't collect prizes after 12 months after death. So I think it's the view of both of us that estates are to be administered. And whilst there might be a bit of toing and froing, if things are going to get delayed considerably, then you need to take appropriate steps. The first remedy is that people often say they can't progress the administration because there's a caveat. So this is my area, if you like. This is where we go day in, day out. People register a caveat and it's an absolutely simple and straightforward process. I get a bit disappointed that there isn't even a statement of truth on a caveat. So the caveat or the grounds for objecting to a will, you don't need to say it. People can just register it. So then when we can serve a warning, it's equally easy for somebody to put in an appearance and then the caveat is made permanent. And it makes me frustrated as a practitioner, as a litigator, that there's no statement of truth. So people will often make unparticularized allegations that, oh, there's a lack of capacity or undue influence or whatever, and it causes utter mischief within the administration of an estate, and then the estate comes to a grinding halt. So the first sort of weapon, if you like, that we've got as a litigator is to, after the warning and the appearance, is to issue a summons in the probate registry. Now, that has lots of advantages because there's no court fees, and the probate registry is quite easy to issue a summons for what's called a put up or shut up order, which basically says, right, if you're just messing about with the estate, then you've got to take action within 28 days. And the probate registrar will and do make an order that says to people, look, you've got 28 days to issue court proceedings, otherwise the caveat will be removed. And so it's a great first line of defence, which is used quite often now. And on top of that, the probate registry are happy to make costs order in favour of the person who's done the warning, and so it's quite a good way to free up the administration of the estate and to make progress with it. So put that one in your pocket. Summons for directions, put up or shut up application. So what would be your alternative remedy, Ian, from a private client point of view?
Well, there's, as an alternative, we know the caveat that gets put on, and usually whoever puts a caveat on, a family member, as you said, it's very simple, very straightforward, and they will crow to the hills the fact of saying they've done it, and they will tell everyone we've done this. They may tell the family, they'll contact perhaps the deceased banks and financial institutions saying you can't do anything, I've put a caveat in place, and they'll do everything they can to disrupt it. And if you're representing a personal representative, they will contact you and say, we put a caveat on, you can't get a grant of representation. And that is correct. You can't get a full grant of representation, but the non-contentious probate rules does allow for limited grants to be issued in certain circumstances. And one of those is an ad colligenda bona grant. Now, ad colligenda bona, we don't like Latin terms, it confuses the public, but it means for the collecting of the goods. And it comes from a long tradition of English common law. So there's no statutory basis for it. And if you ask 10 different private client lawyers what is an ad colligenda bona, they'll give you 10 different answers because there's no one single definition of what it is and what it can do. But generally, an ad colligenda bona grant is a limited grant which is issued by the court to allow someone to administer a deceased person's estate for a very specific limited purpose. Now, that could be because there's doubts over the personal representatives who they should be. It could be that the values of or the assets can't be ascertained. It could be because there's doubts over the will validity. All those things are the reasons why the caveats are in place. But if there are circumstances where a grant is needed because an action needs to be taken, then the courts will acquiesce and agree to an ad colligenda bona grant being issued. It vests powers in a grantee, so it doesn't actually have to be the personal representatives. It can be anybody, any third party can be appointed to make an application, and it gives them power to act for a specific purpose. So rather than let the property sit there going to rack and ruin because it can't be sold, then it can, give authority to say that the grantee can dispose of the assets. Now, what it can do is it collect them all in, so it can sell the property, it can encash the premium bonds, but it can't distribute the assets, as it were. So it's limited to the purposes that of taking actions. Now, this could be, as I said, sale of a property. It could be the running of a business. There could be all sorts of actions where action is needed, but it gives that person the authority to take action. So it means that house doesn't have to go to rack and ruin. It can be sold. The assets can be put into a pot and left securely because it can't be disposed of. So that may go to a solicitor's client account or so on or so forth, but it just means it's there and the values are not deteriorating. And as you said, it's properties, it's share values, and values go up and down. It's premium bonds. It's all of those things. It means you can collect in and keep the administration going to a point. You just don't get to distribute. So ad colligenda bona, it can be used in those circumstances. So even if there's a caveat in place, now there is a process that you go through, and you can give notice to everyone who's involved in that litigation. And it's one of those things of saying, if you want the detail, you can contact us and we can go through it. But it just means it's an alternative. Rather than sitting there doing nothing, you've got some actions that you can take.
Yeah, I think in that you said a couple of things that were quite interesting. There are now about 10,000 caveats issued a year. 10,000, so it's a significant number. And one of the things that surprises me sometimes as a litigator is that people just leave it. They don't take either of the steps that we've outlined. And in the old days, when everything was better in the old days, people would be content to leave a house just sitting there because they think, well, the property market will go up. But those days are gone. There's so many risks to just leaving a property or assets. And so the other thing that I would say as a litigator is it actually makes things much more real, because if somebody's administered the estate in terms of collecting the assets and paying the debts, you can make things real by saying, look, there's a pot of money here now which is available for you almost immediately. If you can agree, and it focuses people's minds because they can see what it is that's in dispute. And you don't want people arguing about small sums, but you can say, look, here's the money. How are we going to carve it up? And when people leave the house, there are other dangers. I remember being a little kid walking around the town where I lived, and there was this huge house up a hill. It was dominating the town where I lived, and it fell into rack and ruin. And I wasn't even a lawyer then, but when I qualified, it was one of the first things, one of the first contentious probates I did, and we got it sorted out. But the house had been left by then for so long, it had to be demolished. So getting the grant even a limited grant is the beginning of the end of a dispute rather than letting it drag on forever. But Ian, you've not quite said how it is that you get a grant ad collegienda bona. So how do you do it? Where do you go? Talk me through that, Ian.
Well, in terms of, you're right, ad collegienda bona grants are the most common form of limited grant issued by HMCTS. Now, the thing to say is they are a longer process than the normal process of getting a grant, because the process is defined currently in the non-contentious probate rules. You have to go sort of flicking right the way towards the end to find them, but it didn't start with the non-contentious probate rules, which themselves were 1987, so many years old. These roots go back long history, all the way back, in the Boer War, you had army officers disappearing off to South Africa and being named as executors of estates, can't administer them. So, the legislation comes on, but it then traces further and further back all the way to sort of the court of King Henry VIII. So these have long histories. The current process is, as set out by the non-contentious probate rules, is you have to put an application in to HMCTS for an order that a grant of ad collegienda bona be granted. So you've got to put in a witness statement with a statement of truth setting out the grounds for the application. So what is the reason that this has come about? So there is a hurdle that you go through first. You've got to set out the meaning of that. That goes into the registrar. Now, as I said earlier on, you ask 10 different private client lawyers, they'll give you 10 different descriptions. There is not a long list of all the reasons that you can be granted. Every single circumstance is looked at on its own individual facts. Now, you can say, yes, we've got historic cases, and if it's analogous, then they're more likely than not to be issued. So if you have got that sort of classic example of, someone who has been in the middle of selling a property, has exchanged contracts and died before completion and they need it urgently, that's one that is fairly commonly used and cited, same as selling a business and you die between exchange and completion. But you put the application in by getting the request for the order. It comes back as the order is granted, and then you go through the process of an application along similar lines to a standard application, but you're noting the application to say we want only a limited grant, and the person applying doesn't have to recite anything about if it's a will, or an intestee doesn't have to do any of the clearing off or anything from that point of view, because it's to them as a grantee, not as a personal representative. So there is a steps and process that you go through, but it's stage by stage by stage. It then ends up with the grant being issued, and it makes it very clear that the grantee is named on the face of it, and it can then be used to collect in the assets, and it is clear that it is an ad colligenda bona grant rather than a full grant on that basis.
But again, Ian, you and I have been in discussions about this because there's still problems with it, because the wording on a grant isn't always settled. Because sometimes they'll effectively say, and I'm paraphrasing now, look, the grant is limited to the calling in and collection of the assets of the estate and paying the debts. But then sometimes the probate registry will recite that and then add some words saying, for example, including the sale of 1 Arcacia Avenue or whatever. And so you and I have been having this debate about whether or not you need those particular additional words. And if you do, whether those words will stop you selling other property or dealing with other aspects of the administration of the estate. And then there's another hurdle with the land registry, isn't there? Because that often causes problems for practitioners too, doesn't it?
You're right. Now, the fact of saying the common example is the sale of a business or the sale of a property, and so it's been commonly developed over the last couple of decades, where if there is that particular issue and it's been recited, and you say they die between exchange and completion of 1 Acacia Avenue, then the probate registry will recite the fact of saying it's specifically for the sale of 1 Acacia Avenue. The land registry, having seen the named property, will allow the transaction to go through. However, if you just got a general ad colligenda bona without that extra wording in, the land registry are now tending to act as a sort of a secondary policeman, saying we want extra information, and we will only tend to issue and go ahead with the transaction if the property is recited. Now, there is nothing in the requirements that says the property needs to be named on the ad colligenda bona grant itself, because going back to the very point of it, it may be the reason why you've got it is because there's a doubt over a will validity, there's doubt over who should be the personal representatives, or there's doubt about the assets and they can't be ascertained. So it could be that one of the assets that you need to collect in or deal with is completely unknown at the time the application is made. So therefore it's an impossibility to recite all the properties at that particular point in time. And it's something that has to be worked out with the land registry. They have a practice direction that they have, and they specifically address ad colligenda bona grants in that. Their preference is to have the property named on there, but if you're unsure, it's best to leave all the properties out of it, and then it should be applied to allow you to sell any of the properties in the deceased name rather than actually having to have them recited. But it is a difficulty, and it comes back to the fact of saying an ad colligenda bona grant is from the common law, and we have a beautiful history of common law and judges making decisions going in different directions. There is not a statutory basis on this, and therefore when you have something like a statutory body like the land registry, it means that they have to sort of interpret it in the best way that they feel, which may not be the right way according to the common law.
Right. Well, thanks for that, Ian. I started this by saying that we came at this from diametrically opposed ends of the spectrum. But I think, again, we both meet in the middle in terms of, and I'll say again, estates are to be administered. And if people are watching get stuck, we always say, don't get stuck. Just give us a call or send us an email. We give guidance and help people to deal with the administration of an estate. All we do is litigation, so we don't do estates. And so if people give us the contentious bits, we give them back the work to deal with the administration. Don't suffer in silence. My colleague Martin Holdsworth says, bring out your dead. He says that's a phrase he uses. If you've got these files that are problems, just talk them through with us. So if you've got a problem, rather than sitting on it, because you'll only just store up problems, we shouldn't be seeing properties that are empty after 10 years. Give us a call. So thank you, Ian. thank you for joining me today. I hope everybody watching has enjoyed our 2 talking chairs, and thank you for being with us. Bye-bye.
Thank you. Bye-bye.